One of the most frightening aspects of sexuality is the extent to which it can be abused in the form of crime. And what we've done is gotten a district attorney who's prosecuted sex crimes for 20 years. And he's a fascinating speaker with fascinating stories, and he gives us the inside track on the prosecution of sex crimes. So Ron, how did you get involved in prosecuting sex crimes?
That is an interesting story. About 22 years ago, I was working in a DA's office in the middle of the Mojave Desert. It was a small office with about 4 prosecutors. And one day, detectives from the juvenile division of the local sheriff's office came in with a case that they needed prosecuted, and all of the other attorneys immediately ran to their office and closed the door. And I was the only one left, and they came into my office. I didn't have the sense to necessarily go to my office and close the door. And of course, I inherited a case. And the case was an interesting case involving a high school coach who molested a young boy, high school basketball coach, one who had taken the school to a previous school championship. And obviously, the school was quite enamored with him and very upset when we ultimately filed charges against him. We lost that case after a lengthy and highly publicized trial.
Why?
I think it may have been a product of my inexperience at the time, lack of corroboration, the fact that it was this kid's word against the coach, and the coach was very popular and the kid was obviously gay in a community that didn't accept that type of thing. You know, what's interesting, what's been developing lately, the last few years, and we tried our first one of these just a couple months ago and got a conviction. We've changed the statute of limitations on these types of prosecutions to the extent that today there virtually isn't one. We can prosecute a case that occurred 10, 15, 20 years ago, and 2 months ago I tried one that occurred 13 years ago. Now there has to be a certain level of corroboration, there have to be certain types of protections, but if you can meet those criteria, then we can go ahead and prosecute somebody 10, 15 years later. What I found was we actually had the best of both worlds. I didn't have to put a child on the witness stand. I now had an adult talking about what happened when she was a child. And it ended up being a very compelling case because the jury was able to see how traumatic it is for these young women, even as adults, things that happened to them 10, 15, and even 20 years earlier.
Do you use tricks with perpetrators?
We try not to give up too many of our tricks publicly, but we do. We find that the phone calls work well. There's a variety of names for them. They call them pretext calls, sometimes they call them cool calls. They have if the child is old enough to make the phone call, we have the child call. And we have the child say something to the effect of, you know what we've been doing? Well, I haven't been feeling very good about it lately, and I've been thinking of telling my therapist about what we've been doing. And you know, I think I should do that. And hear the reaction to it. And very often the reaction is, no, please don't do that. They'll send me to jail if you do that. Well, those cases don't go to trial. I mean, obviously that's not going to go to trial. We had a pretext phone call in the last trial as well. Juries listened to them. There was a time that some jurors tended to be upset over the use of surreptitious telephone calls. Some of them even considered it a form of entrapment. But you know, we explained to them it's a way for them to get the most amount of information they can get, not the least. That they should go into this trial and go into deliberations with as much information as they can possibly have. And if that includes a phone call that is designed to elicit a candid statement from somebody, I mean, understand, if the guy really did do it, then he's going to be very perplexed at how to handle this call. He's going to have either a small child calling him and saying, I don't like what you've been doing and I want you to stop and I'm thinking of telling my mom. Or he'll have the mom. And the instructions we give the mom is to call up and say, I know what you've been doing to my daughter because she told me what you've been doing. I'm not going to call the police, but I want you to tell me exactly what happened and what you did, and I want to know if you have any sexually transmittable diseases, and I want to know the last time you were tested for AIDS, and I want an apology from you, and I want all of these things, and I want it now. Now his dilemma is he doesn't know for sure whether the cops have been called or not, or whether she's really going to call the cops. But if he did do it, he's more inclined to wiggle out of it than to simply deny it. He knows if he denies it, he's going to piss her off and she will go to the cops.
It seems like that one would use a pretext call in every such case.
We do. Or try to.
Try to.
Or try to, if we know who the guy is and where to find him. It is pretty much routine virtually everywhere now to use those phone calls. And it backfires every once in a while. Every once in a while the call is made to somebody who already knows it and is pretty much presuming that someone's on the line. And they say, I really don't understand what this phone call is all about. Sorry you don't feel particularly good, but it sounds like you're making an accusation against me that's simply not true, and I'm not going to stay on the phone any longer. You go call somebody else. You want to call the police, go ahead and do it. And then hang up. We see that every once in a while. Of course, from the defense standpoint, that's the best response. Well, if that happens, you don't have that as evidence for the prosecution. That call ends up being evidence for the defense. About a year ago, we had a case that was a home invasion rape of a young woman, and then 12 days later, he went back into a home about 50 yards away on the same street, this time in a room with two young women. I don't believe he knew that there were two actually in there. And attempted to rape one until he realized the second one was there, and then tried to quiet her down. All of these were at knife point. And then the first one ran out of the room, and he never did anything in the second assault. And we were able to apprehend him about 10 days later before there was anything more. This is a commentary on the value of DNA evidence. When we brought all three of those victims into the jail to do a lineup at the jail, where we had the suspect in this case, along with 5 other people who looked like him. Same race, same age, same size and height, same general appearance, same general coloring and complexion. The amount of facial hair and head hair fairly consistent, so that all 6 of these people looked pretty good. It was a good lineup. If they had been able to pick out the person who did it, it would have been a good identification. The first one, the woman who was actually raped over a period of 2 hours, mostly with her head down into the pillow, but she had an opportunity on a couple of occasions to see his face. She looked at this collection of people, and she looked at number 3, the person in the middle, and she said, I am pretty certain it's number 3. I'm not completely certain, but I'm pretty certain it's number 3. The other 2 young women, the roommates, and again, all 3 of them were seated at different places away from one another in a darkened room, not looking at each other, but looking at the 6. The other 2 both made the following observation. It's number 3. I'm absolutely certain it's number 3. There's no question in my mind. Now, what would have stopped a prosecutor from filing serious rape and attempted rape charges against that particular person for these 3 assaults? And the answer is nothing, except the person who did it was number 2. He was standing next to him. Number 3 was in fact in jail at the time that happened. We happened to have and recover DNA in that case, and the DNA was so discriminating that we were able to say that the profile generated by the DNA recovered from the crime scene of victim number 1, from his semen, was so distinctive that only 1 out of every 10 trillion people have that particular profile. Well, of course, there's only 6 billion people on Earth, so we're talking about unique to everyone who lives on Earth, and unique to everyone who has ever lived on Earth, and probably unique to quite a few primates. Okay? But the significant thing is that the jury convicted him, notwithstanding the fact that all 3 victims identified, and 2 of them, with some degree of assurance, the wrong man. The wrong man. So we don't underestimate, first of all, the power of a human being to make a wrong identification, and 2, the power of science to correct it. And we were able to get a very dangerous person locked up with a lifelong sentence now, in part because of the presence of DNA evidence. Now, that obviously is something that didn't exist 20 years ago. And 10 years ago, when we handled the first DNA case in this county, we dealt with a science that was not nearly as predictable and not nearly as sophisticated as what we have now. I would say that if there's been any single significant change in the prosecution of sexual assault cases, it would be the discovery of DNA technology.